Okay, ChatGPT gave me the topic of no, that's not it. How to protect your assets with estate planning. And this goes to prove that ChatGPT doesn't know everything. Estate planning, you can't protect your assets with estate planning, technically. Let me explain that. The word estate appears three times in law. One is bankruptcy. So when you apply for bankruptcy and the trustee seizes your assets, what they seize is called your estate. The bankruptcy petitioner's estate. Concede that when a trustee of a bankruptcy court has seized your assets, that's the opposite of asset protection. So the word estate is a legal construct. And let me illustrate by the reference to the second time estate appears in that law, and that's probate. So estate does not exist until you die. And it's a legal construct in which it means the assets of a dead asset owner. Can't take it with you. All of estate planning law has always orbited around estate transfer. That's what it focuses on. Like a living trust is about estate transfer. You pass away, transfer title of the asset to a living heir without probate, I guess, is the big value proposition. Estate transfer. The word estate also appears in the tax code in reference to that which the IRS can tax. But that's it. Now, if the word estate technically means assets of a deceased owner or somebody who's had their assets taken from them because of bankruptcy, then really it's too late. Asset protection is different. The body of law is different. The strategy you use for asset protection are different than simple estate planning. Almost everything that you see on YouTube and other places, they will lead you to believe that asset protection can be accomplished by simple trust. That is not the case. The video I made yesterday about living trusts this proves it. The word revocable living trust, the tax code does not even use those words. It uses the words grant or non-grantor trust. And so anytime you hear living trust, just immediately inside your brain go, okay, this lawyer doesn't know how to protect assets. The value proposition is estate transfer. You have to die before the benefit is triggered, and it benefits other people who receive the asset. Now, compare that to asset protection. The definition of asset protection, at least as I define it, is repositioning of wealth so that the wealth cannot be reached by a creditor. And a creditor would include government agencies or third-party private parties. There's a million examples of successful asset protection. For example, homestead. That's the easy one, right? If, like Florida, remember O.J. Simpson, how he won the criminal case, but then was sued for civil liability and moved to Florida? That's because the amount that O.J. Simpson could protect through Florida's homestead exemption was much higher than other states. Another example would be on a Medicaid application, a personal residence does not count as an asset. It's not subject to spend down. Now, the equity limit on a home varies from state to state. The equity limit as personal residence on a Medicaid application in Wyoming is half as much as Washington State, which is over $1 million now. I think California just eliminated the asset test completely for Medicaid. Look at abatement. So abatement is a statute in all probate codes in which it's kind of like a construction lien. That's the way I analogize it. If something goes wrong with a construction job, all the subcontractors, anybody that has a claim, start filing liens. And almost always, there's not enough money to go around. And so it's the priority of liens. Who's in first position? Abatement is if there are more claims on the estate than there are assets, who gets paid first, essentially. But the statute lays out exceptions. So that's what you want to look for in asset protection is a statutory exemption. And a great example is abatement, in which annuities, at least are listed as exempt. Like they cannot be attached in a probate fight. And if you look at contractors, land developers and contractors, those guys are like high testosterone, and construction law is basically managing lawsuits. Subcontractors never show up. And it's just like a constant threat of litigation. Any surgeons and physicians, even after they pass away, there might be a claim on their estate. And so the purchase of an annuity under the technical reading of the statute means that that asset is not available to creditors. Wow. Look at Yahu's, Dave Ramsey just makes stuff up. Often they will criticize annuities, but they're not lawyers. They don't, almost every asset you point to, mutual funds, retirement accounts, is created by the law. And if you can go out and purchase an annuity and it's protected from spend down on a probate dispute, oh my God, who cares what the commission is? Who cares what the backload fee is? Who cares about the surrender penalties on a 10-year schedule? It doesn't matter because you just protected that asset. Now notice that had nothing to do with living trusts, right? With that said, there are three kinds of elder or asset protection lawyers. One would be domestic asset protection trust guys. That is an area of law. You think I would practice in that area, but that's all about protection from lawsuits through offshore trusts. And you can choose jurisdictions in which there's no treaty between the United States. There's not very many, actually. You could park your money in the Cook Islands with a trustee with a certain kind of irrevocable trust. And I don't dabble in that area. But some jurisdictions have different systems. So this location, Puerto Rico, there's tax treaties between, it's a U.S. territory. You get a U.S. passport. Puerto Ricans have a U.S. passport. They're U.S. citizens, but they pay taxes through a different system. And there's tax incentives on this island in which Americans can move here and pay no capital gains tax. Wow. That's asset protection, because now you're lawfully eliminating tax. And tax is one of the three threats to your wealth. Number one in order of threat and magnitude is unreimbursed medical expenses. Number two is unnecessary taxation. And number three is family and financial mismanagement. All of those threats can be solved by an advanced trust. One of the reasons that you won't hear lawyers speak of the correct trust is because that's advanced law. And you got to really have game to understand, like an irrevocable non-grantor trust is completely different in skill set and understanding and value proposition from what you see everybody peddling out there on the market. It's trying to sell it as asset protection. Even sites like Susie Orman's sites, her site, I noticed she's restructuring it. So maybe, I don't know what's going on there, but they'll make comments that these are all the documents you need to protect your family and protect yourself, and it's a living trust. That's not an asset protection trust. It's not anything really. Now, if you're married, I'm going to shut up because I'm going to go jump in the water, but if you're married, then what you need to understand is the most important thing you can do is embrace 42 USC, and that's the 42nd chapter of the United States Code. In particular, look at section 1396. In that body of law, there is the authority by Congress, this is federal law, for a married couple to leave the inheritance for the surviving spouse in a trust that's created for the surviving spouse's benefit. if that is correctly set up and it is correctly funded, all of the assets in that trust are exempt for Medicaid purposes and are exempt even for estate tax purposes. It's an exemption. And so that trust is out of the surviving spouse's estate for Medicaid, so not subject to spend down. No transfer penalty applies. 5-year rule does not apply. And if you live in a state with an estate tax, so we're talking Oregon, Washington, there's 10, and right now, Illinois is a $4 million exemption. Connecticut, Hawaii. See, if you live in those states, 10 of those states do not give a married couple two individual exemptions. They only give them one. With a 42 USC trust or a credit shelter trust, you double your estate tax exemption. So that illustrates it perfectly. Advanced trusts that protect the assets lawfully and ethically from Medicaid spend downs and double a tax exemption. That is asset protection, but that's advanced. Like, I double dare you to Google 42 USC trust on YouTube and see if any of these guys are talking about it. So that's it. Oh, one key point, that trust, 42 USC, the best asset protection trust in American jurisprudence, must be created by a last will and testament. The law is clear on that. That's why down on living trust, because a living trust will not work. That trust for the benefit of the surviving spouse must be in a will, and it must go through probate. That's what Congress decided. That's the rule. Asset protection right there. That's how you just think advanced trusts for asset protection for an individual. If you own business assets and you combine it with limited liability companies and S corps and partnerships.